My Lord, if the Constitution were a human being, it would stand here and say, don't be deterred. Give me a fair trial. That is what we had yesterday from Advocate Mnisi, who accused number three's lawyer. Advocate Mnisi didn't just bring legal arguments. He brought fire, passion, and plea for fairness that echoed beyond the courtroom. Let's break down his powerful arguments, his submissions in yesterday's dramatic session of the Senzo Meyiwa trial. Welcome to the Courtroom Chronicles. Mdase. I'm Busisiwe Mohabi, and today's update is all about Advocate Mnisi's head of arguments, his defense of accused number three, and why the court eventually ruled in his favor. Let's get into it. Yesterday, Advocate Mnisi made a formal application of the accused three to be granted time and facilities to prepare a proper defense before examining the state witness, Warrant Officer Mabas. The shocker, the state introduced new evidence 23 months into the trial. That's what he told us. Mnisi didn't mince his words. He quoted international law, constitutional rights, and asked the court, is this fair? His whole argument was grounded in Section 35 of the South African Constitution, the right to a fair trial. That is what we had yesterday. Mnisi gave us a little bit of teachable moments here that I want to share with you. What is Section 35? 3 saying? It says the section outlines the rights of the accused person, including to be informed of the charge in a language that they understand, to have adequate time and facilities to prepare for defense. Number 3, to communicate with legal counsel of their choice. When that doesn't happen, Mnisi argues it's not just a delay, it's a denial of justice. Mnisi's argument, the Constitution speaks. That's what he told us. Mnisi evoked the preamble of the Constitution to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. He argued that his client, Mr. Mncube, isn't asking for the moon. He wants what the Constitution already guarantees. Mnisi emphasized the obligations imposed by the Constitution must be fulfilled. What is a teachable moment that we got from that is that in Article 14 of the CCPR, Mnisi referenced Article 14 of the International Covenant on Civil and Political Rights, which South Africa has signed. It guarantees that every person must have a fair hearing, adequate time to prepare, legal presentation of their choice. This is a global language, but it's also embedded in our Constitution. The highlights, it's calling out the state. Advocate Mnisi wasn't shy yesterday. He said, he reminded the court that the state had this new evidence for 10 years. Hi, Mara guys. This evidence was there for 10 years. But you know? And the prosecution had it over 5 years, and yet only now, mid-trial, they dropped it like a bombshell. His words, that will be a sin for the state to do that, my lord. That will be unheard of. Yeah. If you were listening, then you remember all of these things. What teachable moment do we get from this? Delay tactics versus fair process. When the state delays disclosing key information, the accused loses their chance to prepare adequately. Mnisi called this as bait. A strategy the state laid now wants to escape accountability for it. He also spoke about the international context. He didn't stop at South African law. Mnisi cited Article 10 of the Universal Declaration of Human Rights, Article 6 of the European Convention on Human Rights, Article 7 of the African Charter on Human and People's Rights. Each of these emphasizes fairness, equality, and the right to be heard. This is how he closed his submission. I want you to listen to this. Mnisi ended with flair. If the Constitution was a person, it would say, "Dear Honorable Court, do not be deterred from giving effect to the Constitution just because the Criminal Procedure Act doesn't mention it specifically." He invoked Section 173, which gives courts the power to regulate their own processes in the interest of justice. What was the outcome? We all saw what the outcome was. Judge Rata granted the application. IQ's number 3 will be allowed time to prepare, and the court will reconvene tomorrow. Actually, today, maybe he's already finished with whatever that he needed to do with the dentist of his choice. He said, "Please, can I please have my own person?" And I will go to that person. I do not want to use the state's dentist. I will go to someone who's private, and he was allowed time to do that. So one final teachable moment that we see here. What is Section 173? Section 173 empowers the court to regulate its own procedure. It means that the court isn't limited to what's written in the Criminal Procedure Act. It can go further when justice demands. So what do you think? Was Advocate Mnisi argument fair? Should the state be held accountable for introducing late evidence? Drop your thoughts in the comment section. Like, share, subscribe, and hit that notification button. This is Busi, and I am signing out. Until the next one, God bless.